Good afternoon. How are you today? Hope you're doing well. Welcome to one of HAQQ's podcast episodes. It's lovely to have you and lovely to have this discussion with you today.
Hi, Sam. Thanks a lot for inviting me. Very much look forward to spending the next half an hour, 45 minutes discussing international arbitration with you on the podcast.
When I was told that we're going to be discussing international arbitration and expert witness, I was like, yes, I'm glad I'm going to host this podcast. First of all, because arbitration is a very interesting area for almost everyone nowadays. You see many people just looking or finding a way to get into arbitration. And especially like you see in the construction industry, many engineers want to go into arbitration, expert witness, or as arbitrators. So why do you think there is this trajectory towards international arbitration, especially for experts as engineers and architects?
Okay, no, it's a good question. So I think, like you said, we're seeing a growing trend for contracts to provide that the dispute resolution mechanism is going to go towards international arbitration instead of to local courts, and we're seeing this more and more in the Middle East in particular. So like in Saudi Arabia, I think 10 or 15 years ago it was actually illegal, or it was contrary to Saudi law for government entities to enter into any arbitration agreement whatsoever unless there was special permission from the Minister of Justice or one of the Ministers of Infrastructure. But now it's actually shifted entirely to the other way, where for infrastructure projects and certain projects, government entities must enter into arbitration agreements. So you've seen this kind of radical switch, and I think a big part of that is to increase the confidence of international entities, contractors, construction companies, banks, whatever it is that are looking to kind of enter these markets and provide services in these markets, and to increase their confidence that in the event that there is a dispute with the local government authority or the state entity, that they're going to have an international dispute resolution body, and they're not going to be subject to the local courts.
Indeed, especially in some countries or some jurisdictions, there's a certain degree of fear because of how much immunity state entities hold. And you mentioned Saudi Arabia now with their new investment law and the new investment framework. It's more arbitration friendly, and it explicitly mentions government entities.
Yes. Yeah, I think that's
so
right.
I'd like
and
to
then,
take it. Yes.
Sorry to interrupt. I was going to say, but you also did mention the growing trend of experts shifting into the space, engineers and the like, wanting to kind of provide expert services in the space. And we are seeing more and more, engineers, at least in the field I practice in, which is construction, energy in general. It's, you see a lot of engineers, you see a lot of surveyors, you see a lot of quantity surveyors, people that we would describe as programmers who now become kind of delay experts on projects. And they're shifting more into this space. And the reason why we're seeing them, I think, more in international arbitration as opposed to litigation in the Middle East, but even here in England and Wales, is because a lot of the large infrastructure projects are providing for international arbitration. So when they want to provide these services, that's the sphere that they enter into. But there is a much growing trend of these industry professionals that are kind of used to historically working on projects and actually working on the day-to-day side of the projects themselves, now moving into dispute resolution and advisory work, because there's just a big growing demand for these services. I think, yeah.
And especially when there are dispute boards, whether adjudication or avoidance boards, sometimes you see lots of experts on these boards because it's a pre-dispute phase, maybe. But here I'd like to look at the role of the experts, not just in terms of witnesses. How do you differentiate the expert's role if they were standing as a witness or if they were standing as an arbitrator? how much space does an expert have in terms of including their expertise as an arbitrator rather than a witness?
I mean, I think it's again, that's an interesting question. It's a good question. So you'll have different, I think, types of experts that could get involved in proceedings either as an expert or as an arbitrator. So sometimes you'll see what we describe as technical experts, which is, you know, your typical engineer, quantity surveyor, who, you know, can provide expert witness services for a party. In that capacity, they're meant to, you know, bring their technical experience and expertise and then produce an opinion that the tribunal would rely upon in coming to its decision. They're meant to be impartial, they're meant to be independent, but also they need to balance those obligations with the obligation that they do owe a duty to their own client to assist them in advancing their case. There's recent English decisions that would say they're part of the litigation team. So they kind of find themselves in a not too different position to lawyers, where lawyers have always been recognized as owing an independent duty to a tribunal or to a court, but also have a duty to the client to help them advance their case to the best of their abilities whilst lying within those duties. But then you'll find, you know, now we're also seeing a growing trend under contracts, especially large infrastructure contracts, where there is the ability to engage experts as deciders of disputes and you see them sometimes as part of what you just mentioned, a dispute advisory board. Typically there you'd have a technical kind of person. You'd bring technical issues that have occurred in the case where each side says technically, you know, a certain narrative or thing happened, and they need to determine that. Usually with a dispute advisory board, they make recommendations that are non-binding. So it's open to the parties to then, you know, say that they don't agree with that and take it further, maybe to an arbitration. But also we're seeing more and more of a trend now for these types of dispute resolution mechanism called an expert determination, where you bring in a technical expert who actually listens to these technical types of issues, but has the capacity under the contract to make a binding decision. And we even see in some instances, technical experts being part of a 3-person, say, tribunal, sitting with 2 legal professionals as part of a tribunal, and they would then bring some technical expertise and know-how to the tribunal when they want to decide the dispute.
That's like exactly the last sentence you mentioned is what I wanted to build on. And because if you see, if we were to compare, I know the comparison here doesn't feed much right into it, but if I to compare arbitration to litigation, where the judge, even though he might be aware of some technical aspect, is not allowed to bring in his technical expertise or technical know-how into the decision. While this is not the same for arbitration, you would see an engineer who's sitting on an arbitration panel bringing in some of his engineering know-how into the decisions. Does this actually contradict the impartiality and the principles of arbitration?
It's a good question, and I think you are right, because usually, you know, if you're before a court, the court should not be bringing in kind of very, very specialized knowledge that neither party has put in as evidence into, you know, the purview of its decision-making process. They can rely on, you know, things that are kind of in the common knowledge or kind of within, you know, the court's sphere of knowledge in determining things. But those are usually quite, you know, simple, generally quite basic things. But the rules of evidence in arbitration can be, you know, quite lax. Now, the starting point's going to be, you know, what are the terms of reference between the parties? What's the arbitration agreement between the parties? Because typically the arbitrators are going to be bound by that. And if it say for some reason explicitly prevents them from bringing in their own knowledge and they just have to rely on the evidence of the parties in making a decision, that they could in all likelihood be bound by that. But let's assume that's not the case, because you don't typically see that. I think that they can do so, but they need to at least be seen to be affording both of the parties fairness with this. So if they just drop it in at the end to say as part of their own award, without having given either party's expert or the parties themselves the opportunity to consider this or deal with it or respond to it, they might not be seen as having afforded both parties sufficient procedural fairness, such that, maybe those parties then have, or one of them has the ability to successfully challenge the award before the local courts. But say, they listen to two experts and they say, hold on, I also, I have technical knowledge in this field, and I think this might be the case. What do you guys think about this? That I don't see any real issue with that. And that could be one of the strengths that an arbitrator like this brings to a very technically heavy dispute.
I know an arbitrator who's a lawyer by practice, and he serves mostly on like construction disputes and other disputes. And whenever he's on a tribunal with two other arbitrators who are experts or engineers, he'd make sure to tell them, okay, so quantum is on delay or on you right now, and then when it comes to the legal, it's on me, because it even gets hard for the lawyer to get into the technical, especially in a very niche and technical industry like construction and energy disputes. So nowadays you cannot talk about anything without bringing some AI into it. And especially now, in many cases, we've seen how courts have dealt with the use of AI, especially in arbitration, and the use of AI, if it's permissible, not permissible, cost allocation. So what do you think about that?
I mean, I think artificial intelligence is an extremely powerful tool. If you feel like it's getting more and more robust and more powerful almost on a daily basis. And I think I saw a stat that, ChatGPT almost doubles in its ability to, it's just its abilities every few days, which is a little bit scary when you think about it. I mean, we already see it. We already utilize it in practice. It's got, the ability to say churn through hundreds or thousands of pages for you very, very quickly, identify, if certain things are said or not said, if there's evidence on certain things that are there. I think tribunals, I think with any new tool or technology that's as powerful as this and that comes in, you have to learn how to adopt it properly, or you're probably going to be left behind. But where do you draw the line with these tools, especially with the technology as we currently understand it and know it? Do you want an AI tool to review all the submissions and evidence and everything that's been filed and produce an award for you? I wouldn't feel very comfortable with that. I'd have concerns about the enforceability of such awards, the ability to challenge them. Whose professional negligence insurance would you pursue if things went wrong? So just knowing where the lines get drawn can be a bit blurry, and I think it's just going to be ever shifting as we move forward with it.
So let's help draw the lines here, and especially in expert witness. Do you think like sooner than later we would see parties relying on AI as their expert witness? Now that we've seen some AI tools that are specialized, you have some legal AI tools that are legally robust, and they're made for legal questions, and then you see AI tools made for engineering and construction questions. So what do you think about that? Is there room for the
I
AI?
think it's, I mean, I could end up being proven as wrong, but I think it's unlikely. I think it's unlikely for a couple of reasons. One, it's kind of the usual expectation of what it's in proceedings as part of this kind of procedural fairness point that parties rely on quite highly, and is one of the strongest grounds that can be relied on to challenge an arbitration award. You want the right to be able to cross-examine the experts that's produced an opinion. And whilst you might be able to type questions into a program and get responses from it, I think, at least the generation of decision makers that currently there, they're quite experienced people that, were practitioners 15, 20, 25 years ago when these tools were not available, would find that quite unusual, would not be ready, very ready to just simply accept that. So that's one aspect. The other aspect, which I mentioned before, is this point about professional negligence insurance. So if you're going to have an AI tool and it gets the opinion completely wrong, and we do see these AIs come up with hallucinations even now and make up fake cases and make up fake points, and you do still need to vet what they come up with.
Exactly.
And it comes up with something wrong, and you hang your hat on it, and then it's completely wrong. Who are you then going to turn around and sue for this? So I think we will still, hopefully, at least for all our jobs, we will still want people to kind of be the face of these opinions, be the face of what's said to the court or to the tribunal.
The human element, I think, is very, very important in determining cases, whether arbitration, litigation, or any other form of resolution. Especially in ADR, now people go towards mediation, negotiation, or arbitration, even though I do not like to call arbitration as ADR, but you need the human element because it is a must in it, especially when there are cultural aspects involved in the dispute, or when you need to study a cultural aspect to the dispute that's around. And it would be a bit difficult for now to do that with AI. But our topic is mainly expert witness, and because there's this increase of expert witness use in international arbitration, do you think it's because legal arguments are not as powerful as they are, or is it because that the disputes are more technical? So are the disputes legal, technical, and why are we seeing this increase in expert witness?
I mean, I think the complexity of the cases has gone up tremendously. I think the size of the projects that you're looking at today compared to, say, 30, 40 years ago are probably larger. I mean, you've got new complicated types of, say, financial litigation that or arbitration just did not exist 30, 40, 50 years ago. And whilst I think, construction projects, if you're building an airport, in the 80s where you're building it today, it's probably the same level of complexity. I think there's all these new types of, fields that have arisen of specialized knowledge that people want to rely on. So, a programming expert might have been something that you would have used, here and there, maybe 40, 50 years ago. But now it's become much more common. The costs of a delay case have become much higher. So I think it's just really all underpinned by how technically complex a lot of the disputes have become, and how much money is really attached to each parts of the claim where you might want to rely on expert evidence.
And I do also have not a different opinion, but something to add on that, because I've attended some workshops, seminars, and many lawyers and professors were explaining the difference, contract drafting principles, and the difference you see between what the lawyers who draft the contracts actually say and what they meant, because what they meant is not usually the same way it is interpreted. So, and I think it is in this gap between what is written and what is interpreted is where you need the expert. Because let's say I draft a clause in which I say I am entitled to terminate the contract in case of any X, Y, and Z breach which lead to damages, or there's this gap, there's this space where you need to identify if damage has occurred or not. And I think this is where a technical argument or a technical answer is needed much more than a legal argument or a legal answer, because it's no longer about the legal interpretation, but rather the technical aspect to it.
Yeah. I mean, I think that's right. I think where there's ambiguity in what the contract says or what it requires the parties to do, that's where, every party is going to quite likely want to rely on opinion evidence as to, to support their respective positions. I think, you see a lot of bargains get made where things are kept a little bit vague just to get the contract across the line sometimes. And then parties find themselves having a fight about it down, a few years down the road. And you might be seeing more and more of these. I think also the contracts themselves, even the standard forms, have just become more and more complicated, over the last, 40, 50 years as well. And there's a lot of different things that have been added into them. So, yeah, I think a combination of all these things has just led to a greater propensity for expert witnesses.
Last week, my guest on the online podcast ended on a note which I think you might contradict, given how much you've been mentioning the complexity contracts are, like the level of complexity contracts are nowadays, and especially in industries like construction and energy. My guest ended on keep it simple, stupid, an advice for lawyers drafting contracts. How much is this relevant in some contracts that require a level of complexity like construction contracts, energy contracts? And can you involve experts in the drafting phase of the contracts to help you have a very robust and well-drafted contract?
Yeah, I mean, I think one of, I think a very sound principle when you're drafting contracts is to keep the language as simple as you can. Keep, the provisions as straightforward, as simple. You don't want crazy long sentences and things that can be misinterpreted or can become ambiguous. So a simple contract is quite good. In construction, we tend to use a lot of standard form contracts. So things like, FIDIC and all the different books, and those have become quite accepted, industry-wide, and arbitrators and judges are familiar with them. And if you don't amend a lot of their provisions, I think there's a lot of, there's many resources and commentary about what all the provisions mean and how they're interpreted, which you can kind of fall back and rely upon. But obviously every contract is going to be unique, and whilst you might have a standard form, you need a scope, you need a schedule of works, you need all of these things, and these are technical matters that, usually the engineers or the programmers, come to together in agreement. And I'm of the very strong view that if you can engage experts in the field, you can employ them, you can have them as consultants that assist you. If you bring these people early on when you're coming into, contract formation, you're trying to agree the scope of works, you're trying to agree the schedule, and you get someone and, their retainers then are quite small comparatively, to the cost of the project and what it's going to cost, to bring them in later on if there's a dispute, and just get them to have a view and maybe give you some tools to negotiate with. I think that's very, very useful.
So simplicity does not mean precision or technicality. So you have to be simple in drafting the contract, straightforward. But if the contract or the project actually requires technicality, make sure you have this technical aspect into it incorporated early on to avoid that ambiguity.
Yeah, I think it's very important. But I think you need, when you're drafting a contract for a very, very large project, you need to cover a number of your bases. So I did a case a number of years ago where, this was a project worth hundreds of millions of dollars for a hospital. And, the lead engineer for the client who owned the hospital was the one who drafted the contract, but decided not to bring in lawyers, which then wound up having, serious issues because he'd use standard form contracts, but he'd use, for one of the, for the initial template, he'd use like a 2014 version, but then for the general conditions, they'd use the 2010, and there were some contradictions in their terms and how they, put an order of priority between different provisions and different documents. And this wound up being, a huge issue later on when the parties were arbitrating and there was ambiguity and it was just unclear how it was going to get decided.
I know we've shifted a bit from experts in international arbitration. I'd get back into it, but just one more quick question on this one.
Sure.
Uh, do you think like contract drafters should be involved in dispute resolution, or are they two different things?
Sometimes, I mean, it depends sometimes on the jurisdiction. There are jurisdictions that actually allow you, I think, to rely on what was the party's intention when drafting, if there's any ambiguity or disagreement as to their terms. Other jurisdictions would say you can only look at the four corners of the contract and you can't go outside. So I think if you're in a jurisdiction where you can rely on what was intended, some correspondence around these provisions, so on, you have to have these people, because it's going to become fundamental to how the provision gets decided by a tribunal as to actually what was the intention of the parties. But then, I mean, if ultimately, I think, you know, there's this common saying among lawyers. It's like, you know, don't, you know, if you know, a person represents themselves as a fool for a client, right? And so I think, you know, the point of that is more so to say that if you're emotionally invested in the outcome of something, because the outcome impacts how you're seen to have done things back in the day, you're probably not the best person to be litigating these things, because you're not going to look at it in, you know, typically you won't be looking at it kind of objectively. So to the extent that I think you then bring someone else in to look at it objectively without having the emotions attached to, no, this is what I meant, and that's and this is what we said, and all these types of things, it's probably in your benefit.
I always say that in a profession like the legal profession, you have to be emotionally detached from the whole case. One, not to take it personal, and two, to have the objective arguments rather than what you think you meant or is right. Okay, back to experts a bit. And speaking of the emotional attachment to it, how much do you think experts affect the outcome of a case, especially when the tribunal is made of experts and arbitrators of a legal background? Could it be very determining?
Yeah, I think they can be absolutely fundamental. So if you've got a case, you know, that relies on quite highly on, you know, say it's who's responsible for the delay for the construction of a project, the delay experts are going to be probably the most fundamental part of this case, and you're going to want to have the expert in your corner that is the one that the tribunal sees as the most authentic, the most impartial, and that who's got the better opinion. And your case will probably live and die with them, I would have thought. You know, in these cases, obviously, someone like me plays an important role, because especially for the delay experts sitting on the tribunal, they're going to want to be able to understand these points. There might be some legal points that, you know, they need clarification and clarity on, and we're the ones who draft the submissions, and we package it up in a really nice, easy to read way. But as nicely as, you know, I or you or any lawyer can draft, if the underlying evidence that we're relying upon is just not helpful to us, there's only so much we can do with it.
From the number of cases you've worked on in construction and energy, I think you can make up pretty good engineer by now.
You learn a lot in this industry, actually. So I spent, I don't know, years ago, I spent like a year working very closely with a fire safety expert. And now all of a sudden I know a lot of stuff about sprinklers and how far they need to be apart, and you know, fire doors and how thick they need to be.
I think when you walk into a building now, especially in England, and you see lots of fire doors, you can instantly know if they're compliant to health and safety regulations or not, and if it's properly done. It's the instinct.
But the converse is true. So if I walk into a very crowded restaurant or concert and I look around and I'm like, there's way too many people for the space, and the closest fire door is, you know, 1,000 people away, I'm like, this is not complying with fire safety standards for sure.
It becomes an instinct. That's all you think about, and then later on you apply it into your personal life. If if you're working in your own house and you get an engineer or a plumber, someone to do the job, and you're afraid to interfere, but you still know the answer.
Yeah,
And
for sure.
do you think it actually helped you? Like, how difficult is it for a lawyer who's not that technical to work in an industry or a sector like construction and energy? And I'd like to end on this note. Like, what's one thing you would leave with lawyers working on construction disputes or energy disputes?
Sure. I mean, I think construction and energy and engineering and energy disputes at their core are legal disputes, like almost any other dispute. So you bring a lot of the usual litigation strategy and tactics and thinking that you would, if you had a banking and finance dispute or a general commercial dispute or a fraud dispute. So the strategy and the tactics and the way that you need to kind of distill it and present it and simplify it is the same. I think one of the difficulties that you find in these very, very technical fields and, construction, engineering, energy, but even say, very complicated finance arrangements that you just don't know much about. When you first pick it up, it's quite difficult for you to get a sense of where things lie, because you don't understand these things. And that's where we find that having independent experts that can explain things to us and get us to understand these issues, it becomes fundamentally important, because the client has their own engineers and their own people. But like we discussed before, and you will rely on them a lot, and they form a very, very important part of the team. But like we did discuss before, they have that emotional component attached to it, where they're invested and they have to be right. But meanwhile, if you have an independent expert that's there also kind of overseeing what they're saying, they will bring to you this kind of more objective component. Will be like, the client's right about these issues, but we might have some gaps here. So they're quite important to us to give us a good sense of where the client's merits lie. And then that enables us to advise the client, I think, a little bit better kind of early on as well in the dispute.
So just think about construction disputes, energy or engineering disputes, like any other legal dispute, any other legal issue. Bring in your legal skill set, your litigation skill set to it, and then wherever necessary, add the experts, ask them, learn from them. And I think that's very important advice and technique to go with. And probably it decreases the fear people have, because I think it when you tell people you work in construction disputes, and they reply, oh, this is an industry I stay away from.
Yeah. But I mean, it's also it's a very interesting industry. It's the size of the disputes tend to be much larger than many of the other disputes that you'll deal with, because as one very senior partner that I used to work with told me, he's like, most arbitrations, they revolve around 1, 2, 3 issues. He's like, a construction arbitration might have 50 or 100 issues, and it's just many different arbitrations encompassed into one. And you do need to be a bit of a quick learner. You speak to the experts, you do your own research. Sometimes you read some articles about technical things, but I think any good lawyer can wrap their head around it.
Okay, thank you so much, Andrew. I really enjoyed this discussion. I learned a lot from you, and I hope viewers and people who watch this later on will enjoy it and learn from it, and I'm sure they will. Thank you so much.
Thank you very much for inviting me.